Hello, welcome. Ooh, sorry, that was a little loud. Hope everybody can find a seat. Um, we're starting a little late because, it's LA traffic parking. Welcome, and really glad you could all join. And I'm Melanie Sill. I'm the head of news and programming, the vice president for content here at KPCC. And before we get going, I wanted to do some quick sense of who's in the audience. How many people here are KPCC members? Oh, that's fabulous. Thank you. You make possible everything we do, including tonight's event. How many people are in law enforcement? Thank you. Thank you for being here. How many people are lawyers or in the legal profession in some way? Thank all of you for coming. And how many people are journalists? Good. Thank you. And how many people are just concerned citizens who care about these things? I think that would be all of us, right? I wanted to say that because we all have a stake in these issues. These are not issues between journalists and law enforcement as opponents. They're not issues that only judges care about or decide. They're issues for all of us as citizens. And I have been a journalist for many years, and I'm also on the board of the First Amendment Coalition. And obviously, I've been in the position of advocating for access to public records and access to government for much of my career. But these issues have a lot of nuance, and sometimes, there's a lot of balancing to do, which of course our judges are in the position of doing. They're not always simple questions, and they're not always questions where we're really on opposite sides. And so that's why I'm really happy to be part of this event tonight, where we can bring together people who work in these areas, and also all of you, people who care and know so much about these issues, to participate in this conversation. So thank you for taking time on such a beautiful evening to be with us. I'd like to introduce Peter Scheer, who's Executive Director of the First Amendment Coalition, which is based in Northern California, serves the whole state, and also national issues involving First Amendment and open government issues. Thank you. Peter?
Well, thank you very much. Thank you, Melanie, and thank you all for having me here and for coming out on this beautiful night. So the topic of tonight's forum, information about police and police activities. That's the specific issue that we're going to be talking about. But to put it in context, for me, the larger issue that we're really here to talk about tonight is democracy, the state of democracy in the United States today. Because the reason we care about access to information about the police department, access to information about any part of government, is because democracy only works if the people are able to hold their elected officials accountable. And accountability requires transparency on the part of government. Without access to information about what government is doing, what government's policies are, what government's practices are, the difference between what the policies and principles and rules are on the one hand and what the actual practices on the street are. Without information on those things, it's not possible to hold our public officials accountable. It's not possible to have a democracy that truly works. And so that's the reason that my organization, the First Amendment Coalition, is so completely committed to the idea of open government, of transparency in government. Not that there are no secrets. There are appropriate areas where government can't share everything that it does with the public, certainly not in real time. But the reality also is that much more information, I believe, than is currently shared with the public could be shared with the public, and to the extent that were it to happen, and maybe my organization can help push it a little bit in that direction, to the extent that can happen, we are all better off. Democracy functions the way it is supposed to. So I welcome you to this wonderful event with these great panelists, and we'll proceed.
If you want to help us tonight and you are a tweeter, a user of Twitter, we're using the hashtag public records. So please do share with people out there in the world what we're doing here. I'd like to introduce our moderator tonight, Frank Stoltz. Frank is a veteran reporter with KPCC. He has covered law enforcement through many of the big stories here in Los Angeles, as well as covering politics and many other topics. Thank you again for being here.
We don't usually hear the clapping on the radio. We're just in the studio and there's no clapping. Thanks for coming out tonight. I love how there's sort of equal parts journalists, law enforcement community, folks who are just interested in the issue. So that's fantastic. I am Frank Stoltz. I cover a lot of police issues, and I'd like to introduce our panelists, get right into this. But let me begin by pointing out there's obviously a roiling debate about policing in America today, sparked by police-involved deaths in Ferguson and New York and South Carolina and South Central Los Angeles. People are asking whether police are using too much force on people, especially African Americans and Latinos and poor people. But they're also asking other questions about policing policies. How much and what kind of data are police collecting on us? What practices are police using to fight crime? And when something goes wrong, what went wrong and why? But getting access to the kind of police records that allow us to answer these questions isn't always easy. In fact, police departments often fight hard to keep information from the public eye, citing worries about tipping criminals off to police practices or the integrity of an investigation or officer safety. The criminals might come after you, the deputies or the police officers. Tonight, as I said, we have a great panel to tackle these tough questions of how much access to police records is appropriate, whether current laws allow enough access, and when access might go too far. I need to put my glasses on. You met Peter Scheer. Next to Peter is Jack Leonard, an award-winning reporter and editor for the Los Angeles Times, who's been in the trenches on this issue for a long time. Next is attorney Missio Lin, a partner at Manning and Cass, who argues on behalf of police agencies to protect information. She represented the city of Gardena in its efforts to keep from public view video of the 2013 fatal police shooting of an unarmed man. Next to her is Jeff Steck, president of the Association of LA Deputy Sheriffs Union. He is a one-time Navy lieutenant and helicopter pilot who joined the department in 1999. Next is Neil Tyler, the number 2 man at the LA Sheriff's Department now. He's spent more than 3 decades with the LA County Sheriff's Department. And at the end there, attorney Rochelle Wilcox, a partner with Davis Wright Tremaine, who represents the Los Angeles Times in efforts to gain more access to public documents. Last year, she successfully argued that the names of Long Beach police officers involved in shootings should be made public. We're going to show some videotape now, and I'll sort of issue a bit of a warning. It is public video that was released this week of a shooting. And if you don't want to see it, I suggest you either turn away or leave the room. As many of you probably know, a federal judge ordered the release of the Gardena police videotape of officers fatally shooting an unarmed man. The police department and city had fought vigorously to keep the video from public view after it paid the man's family and another man wounded in the shooting $4.7 million. The video is disturbing, but it is sort of precisely the type of police record that is in question, whether or not it should be public. So let's take a look at the video now. So we're not here to debate whether or not this was an appropriate use of force. We are here to debate whether or not these types of videos should be made public. And I want to start with you, Ms. Yolin, because you actually represented the city of Gardena, and you argued the public should not see this video. Why'd you make that argument? Or why did the city and the police department make that argument?
Well, quite frankly, the facts of this video and this incident were out in detail long ago in a detailed, lengthy report from the Los Angeles District Attorney's Office. During litigation, while there was still an investigation going on and a pending personnel investigation, we entered into a stipulation with the parties putting in place the protective order. So we argued that once the case was closed, a settlement was funded and paid, that the protective order was still in place. It wasn't about this video, it was about the process and the procedures. And the fact is that the details of this incident were never hidden from the public. They've been quite readily dictated, articulated throughout the process. We filed a motion for summary judgment, and the facts of the incident were laid out in the motion for summary judgment. The actual video that was filed with the court was sealed because it was part of the protective order. The issue here is the process. Technology is way ahead of the law. And when you dial 911 and you're having a bad day and you're sitting in your home and you expect police officers to come to your home and help you, if things continue in the fashion in which they are, you will be a YouTube video. That's the facts. We need rules. We need guidelines, good cause as to what is going to be made public. Otherwise, every body-worn camera video from across the United States is going to be the feeder for a reality television show. And you better, get out your checkbooks for your taxes, because for your cities and counties that want to implement body-worn camera programs, they're going to need to hire a team of editors to blur out faces and remove private information. This is impossible to deal with, quite frankly. And it's not about this particular video. And I can go into the officer's side of
Yeah, we'll get
their
to that
perspective,
in a second. So I know you're arguing procedure, but you're also arguing the overall point that videos, the body cam video, dash cam video should be kept from the public view.
Actually, let me make it perfectly clear.
Yeah.
We need a process. We need guidelines. We need rules. There are exemptions under the California Public Records Act. It appears that the First Amendment has usurped state law.
Well, let's get into that because it was an interesting ruling. But
That's normal, right? I mean, the First Amendment it's a very powerful piece of law. I'm just telling you that the California state law has provisions, and the First Amendment,
I want to get into the limits of the California Public Records Act in terms of getting a hold of information. This was a particular ruling. This video was part of a federal case, as you're mentioning.
Right.
It was part of a federal court record, and therefore, Rochelle, you and the LA Times were able to use the First Amendment. It was not typically, when journalists want something from a police agency, they file what's called a California Public Records Act request. We're going to get into that and the value of CPRA, but let's just finish this piece up first, because in this case, you guys went in and used the First Amendment and said the public has a right to see this video based on the First Amendment.
Well,
news organizations.
I mean, the law, in our opinion, is quite clear that evidence submitted in support of a dispositive motion as a motion for
What's
summary.
dispositive?
A motion for summary judgment, a motion that could dispose of the case on the merits. The Ninth Circuit has held that that is akin to a trial. And so just like trial is open to the public and evidence submitted in the context of a trial is available to the public, and there's a remarkably high standard to close that from the public and to prevent the public from seeing that, the Ninth Circuit has held that when you submit documents in support of a motion like a summary judgment motion, there is a presumption, and a strong presumption, that a right of access applies. And so this wasn't a CPRA case. This was a case about federal court records that applied the uniform law from the Ninth Circuit, holding that parties are entitled to get those kinds of records unless the party who is advocating for secrecy meets a burden of showing compelling reasons why the record should be sealed. And so that is clear in our opinion.
And just out of curiosity, I forget what was your compelling reason?
Public safety, privacy.
Well, let's take those one at a time. Public safety?
Well, first of all, when you release video such as this, there's 3 angles. And sharing, I apologize to the media representatives that are present, but we don't have any control as a law enforcement agency as to how many perspectives will be shown. Quite frankly, there's a public safety issue with regard to individuals reacting to being shown one angle of the video.
What do you mean
now, we
public safety?
appreciate
I'm not getting exactly what you're saying.
the public's reaction without information, which is controlled by mass media, has the potential to set your cities on fire, destroy your businesses, it does. I don't know why that's funny, quite frankly. The fact is that there have been cities set on fire. If it was no justice, no peace, marching in solidarity and peaceful protest, that's one thing. But call Baltimore, call Ferguson, where the business owners, their lives have been destroyed, right? Because they didn't have a peaceful protest. And quite frankly, that is a public safety
And
concern.
that was your number one compelling reason to keep it?
Absolutely.
Okay, and Peter?
And by the way, for example, overreaction and it's basically perspective and perception. Now, Darren Wilson, an officer in Ferguson, Missouri, will never work again as a police officer. Someone tried to beat him to death, and he will never work again, right? My officers do not deserve to be hung, judged in the media without full information. And the DA's letter provided the information without a sensationalistic...
So you would argue for a release of the entire record, including the video? If you want
No,
full information out there, would that not be the logical next step?
The public does not go looking for that information. The media directs the conversation.
Well, why
So,
not
Peter,
have
go
the
ahead.
Police Department, Missy, on its own website, publish all the perspectives, all the video that you have of this incident, with whatever narrative that you wish to include with it, including particularly that written report. Why not, dominate the news, so to speak, on this issue by putting out everything there? You can be sure that everybody is going to, or most people are going to want to see as many perspectives as you have. If you have, 6 segments, each, 1 or 2 minutes long from different perspectives, people are going to want to see those. Frankly, I think it would have been very much in the interest of the police department to do that from the very beginning, rather than fighting this for 2 years. And had you done it originally, it seems to me that people who take these issues very seriously and who would have been reading and listening to the news, but most importantly, seeing all of the videos, would have come away with an appreciation of the fact that this was a terrible tragedy. It was a bad shoot, of course, but these were not, obviously, in any way, police officers who'd gone rogue and were looking for some opportunity to kill somebody on the street.
Missy,
This is a
go ahead and
terrible
react to that, and then I
tragedy,
want to
and
hear
people
from
can relate to
our
that.
deputy
First of all, I'd say,
sheriff's
yes,
rep.
you're absolutely correct. It is a tragic incident, and no one disagrees with that. The fact is that where do we stop? I mean, police work is 24/7. How many incidents would you like us to explain and
No, this is
post?
just one
and
case.
no, this is yeah, that's
This is one case, one
that's-
shooting, and the issue was, should these particular videos at issue in this case be sealed and sealed indefinitely, forever? I guess that was your position. Or should they be available for the public to see, given that it is a case that is in federal district court. The conduct of the officers is being challenged by plaintiffs. Massive damages are being alleged and significant damages that were ultimately paid. Why not, in this particular case, let the public see it?
again, it is not about this video. It is about the process. And
That's the
everybody,
process. The process is you get to choose.
So
right now.
let's-
you're
let's-
saying
you get to
this
decide.
video. Why not this video? The process, police work is 24/7. Do you know how much video exists?
Yeah, but
And
we're
so
not
you want us to take this one because you protest and say there's interest in this one. Give us this one. Well, you know what happens? It's like, well, you gave us that one. Why don't you give us that one and that one and that one and that one? And
Well, I think that's precisely where we might be headed in
I
this
know.
conversation, but we've got a couple things I want to wrap up on
welcome
this.
to the new world. Your
on-
police department's not going to get much police work done. It's,
Well, not as long as the California Public Records Act is around, because it provides a lot of restrictions, and I want to get into that.
It
But you have a
doesn't-
quick point on this?
Yeah, I mean, that's really comparing apples and oranges because this was a court proceeding. And so the slippery slope argument really falls apart because it's in the context of a court proceeding.
This was a court record, and I just want to sort of get a gut reaction to sort of the discussion from you, Jeff, because you're a working cop, you represent working cops. Weigh in on sort of this idea that if you show some of this stuff, as Missy's arguing, you might have riots in the streets. There's a public safety concern, but I understand there's also sort of an officer safety concern.
Well, not that I don't mind being called lieutenant, but when I got out, I was a commander.
Okay, sorry, commander.
And I was in 23 years, and a lot of my life was spent in accident investigation and aviation. And the truth is, it is complicated to analyze any case is complicated. I've watched this over a dozen times, and I have just begun to understand what I see, and I am an expert in the field. Now, that being said, I am very pro-transparency. But why stop there? Show every officer, put all of his video out there. It'll become a television show. It'll be horrific at times, funny at times. It will see the life of what I have, see what I do. I think it may educate our public when they see what we do day in, day out. The ugly things we see you at your worst. We see you on your worst days. We don't see you on your best days. How do you feel when your face is on camera, when you're cursing me or cursing at your wife because you had a bad day? It is a complicated thing. I love transparency, but it is a complicated matter that is going to take a long time to sort out.
So we can expect the powerful union that you lead will be lobbying for more transparency in Sacramento on some of this stuff?
We are a big proponent of all of our politicians to have to wear cameras. We think that more than we want our law enforcement, we want our politicians to have cameras on them 24 hours a day. We think that would stop a lot of abuse.
Jack, you wanted to say something?
We agree on something, I suppose. I'm just curious, though, as a cop who loves transparency, what do you think should be released in terms of these videos? Any videos of shootings, do you think those should be released?
I think each one will have to be taken on a case-by-case basis, and it is going to be complicated. I saw the officer get murdered on camera. If that happens to me, I don't want my death on TV. I think there should be a reasonable, reasoned approach to cameras. But that being said, transparency is important, and we support it. But blind transparency, that's just as bad as saying no transparency.
Let's just wrap up the Gardena discussion real quick, because it's interesting. The video's been released, but the city of Gardena has still appealed to the Ninth Circuit I don't actually know, how does that work? If the video's already out, you've appealed the ruling.
well, this is likely to reoccur. What is a protective
So you want
order?
to set a precedent. So you're hoping the Ninth Circuit will overturn the unsealing of this video. they likely won't because it's the Ninth Circuit, right?
Well,
So are you, I mean, are we?
One can hope.
Is potentially this case going to crack this wide open? In other words, if the Ninth Circuit upholds the ruling and goes to the United States Supreme Court, is that where this is headed, or not? Where is this particular case, do you think, headed?
I have a great deal of respect. First of all, I want to say for Judge Wilson, I've had the pleasure of trying cases in his courtroom, and I am disappointed by his ruling, in particular his failure to give us the opportunity to effectively pursue our right to appeal. I feel that he...
Okay, noted, but
So
is,
our appeal is about the process. When there's a protective order being lifted, a party, whether anyone in this room in that situation, should have the effective opportunity to appeal. We filed our notice of appeal
Okay, so-
within
yeah, sorry.
4 minutes of the order being issued. 4 minutes. That didn't stop the World Wide Web button from being pushed. And that's unfortunate. That's not effective
you've got the guy
judicial
right
process.
next to you who you can, you can bop him one if
He's
you want.
already asked that I not hurt him.
So this is, okay, so what I'm hearing is this relatively narrow, it's a discussion of the ability to effectively appeal.
But I would
Even
agree
if
with
this
Jeff.
goes to the Ninth Circuit and goes to the United States Supreme Court, we're not likely to see a broad ruling on the release of videos that are in court records.
Again, one can only hope. I would agree with Jeff. The process, and probably Rochelle agrees too, we need some rules. We need direction. We need what is good cause for release, et cetera. There's, similar to some of the other judicial processes we have in place relative to personnel records, et cetera, I think we need a process. And the courts typically take a number of cases to lay out the rules.
Well, this is something that's going to be resolved in the legislature, and they've been looking at legislation related to body cam videos and dashboard videos for a while, and it stalled this year, and I'm not quite sure what's going to happen with it next year. But it absolutely has to be resolved at the CPRA level, because not as many of the videos are going to be at issue in litigation. So it's
They
not
won't
that-
end up in a court file
Right.
where you can use the First Amendment to access them.
Will that actually matter? Because that will be state law. Will that
Well,
matter?
it would
Well,
matter in the CPRA context.
this
That's
is-
a different, so for the videos that don't end up as evidence in a summary judgment motion, then the CPRA rules would apply, and that needs to be resolved.
So this is our
Only 1 in a
segue to the,
million of these cases are going to be cases that are contested in court. Only one in a million of these cases are going to be cases in a court, in federal court, where one party is trying to seal, or even perhaps both parties are trying to seal evidence like this, and the media or some other intervener is saying, no, don't seal it. No, 99% of the cases are going to arise when reporters or private individuals, community activists make requests directly to police departments under the California Public Records Act.
and I want to read a
That's our
couple
Freedom of
excerpts from the
Information
Act,
law.
because the Act itself, is fairly lofty. It reads, it should provide access to information concerning the conduct of the people's business and a fundamental and necessary right of every person in this state. Access to government records has been deemed a fundamental interest of citizenship. And it talks about maximum disclosure. In
Except
addition,
when it comes to police records.
well,
There
this is
should
what
be a
we're going
big
to get
footnote
to.
in the statute.
In addition, for those who aren't familiar with the CPRA in the audience, any journalist is, but it also was amended to say agencies must respond to a public record request within 10 days. It must provide electronic records in their native format and provide a reason for denying a request. And then there are the exemptions that are fairly broad as they relate to police agencies. So why don't you just pick it up from there?
Well, it's very quick, it's very simple. There are a lot of exemptions in the Public Records Act that are sort of can be applied different ways depending on who's applying them, and we can argue about them, and there are subjective standards and so forth. But when it comes to police investigative records, they are 100% exempt from disclosure, from required
And what
disclosure.
are police records? Jack, you've filed a few of these things.
But let me just add one more thing. They are categorically and totally exempt from required disclosure. But unlike some other things in the Public Records Act, the police have the discretion, if they wish, to release them. And that goes to the question I was asking Missy earlier. Why not, in some of these cases, certainly, perhaps most of them, release these videos at the discretion of the police department until the law changes and forces you to do so, where the public's need to know and interest in knowing in a particular case is just compelling compared to the interests on the other side. And while there certainly are tough questions about personal privacy, like seeing the faces of witnesses or victims at their very worst moments, when the police are confronting them, and we have to deal with that, there are ways to deal with that. There are ways technically to deal with that by pixelizing those faces, for example. Google does it 1 million times a day with Google Street Smart, right? And there are other things that can be done. And the police, because they have the discretion to release these if they wish, then they should exercise that discretion, release them whenever they can, and take appropriate measures to safeguard the privacy interests that they say they're so worried about. And then the public will have a chance to see what really goes on.
Well, and it's did you want to respond, Joe?
So we're going to alter some of the video we're going to release. You can't have it both ways. You can't alter some video and not alter others. It's either transparent or it's not. You can't.
You redact records all the time, and it's specifically approved of in the law.
I think altering a video is different than blacking out something in a record.
No, you're pixelating a face. I think it's the same
What's
thing.
interesting is we're not just talking about videos. Often we're talking about internal reports, and here in Pasadena, obviously there's a roiling debate about the release of a report on the fatal police shooting of Kendrick McDade, where the city hired an outside independent group to evaluate the shooting, to evaluate the officer's behavior, what went right, what went wrong. And the police officers union is pretty strongly opposing the release. So it's not video. It's not the names of officers, although that's part of the issue. So does anyone want to sort of take that one up? Nobody wants to take. Does anyone want to argue?
It's pending before the Court of Appeal. It was argued on June 30th, and a decision will come out in the fall, maybe sooner.
Did you argue that case?
No, my
okay.
partner. I was on the case, and my partner Kelly Sager argued it.
Okay, Kelly argued it. All
And
right.
I don't have the specifics of that case, but I would take issue with Peter's comments that this doesn't happen all that often. Quite frankly, in our federal law enforcement cases, civil rights cases, we have protective orders in place all the time with regard to stipulations, and it facilitates the process so that we're able to give the parties, the plaintiff's counsel, disclosure that would otherwise be a massive battle in federal court in discovery, and it moves the process along quite freely with the parties, the people that need to know. And I take his comments about what the public wants to know or needs to know. Well, who is the public? If we didn't have a lot of people clamoring, no, actually, we had nobody clamoring except the LA Times asking for this video.
Well, but in
Ever.
all fairness, the public can't necessarily be expected to know about all of the events. I mean,
I'm just
about
no, it was out
they
there.
may not have even been aware of
The
the incident
news,
itself.
no, the shooting was covered. The news was out there. We held public forums. We had discussions. It was out there.
I want to hear from you, Neil, in just a second. But Jack, make
The
your
fact is,
point.
with that shooting, there were two very different views of that shooting that were given in that lawsuit by the two sides that had each looked at the video and said they showed something very different. On the one side, you had the city of Gardena saying that it was a justified shooting, that these were people who had not obeyed the police officer's commands, and that there was nothing wrong. On the other side, you had the plaintiff's attorneys who were saying this was a cold-blooded shooting. And so anyone who was to review what was in those documents wouldn't really know for themselves what happened. Now we do. Now you can get to see the video, all sides of it, all angles that were released, and see for yourself. And it's the public who ends up paying that $4.7 million to settle that case. And it's not just the people of Gardena that pay it. Correct me if I'm wrong, but it's the taxpayers involved in the insurance, conglomerate, the group of insurance of the cities that are involved in that insurance joint powers authority.
First of all, the city of Gardena never said that the shooting was completely justified. The city of Gardena, the officers, it's tragic. Is it defensible? Is it understandable?
I don't want to
That's a
belabor
different
Gardena, but I
issue.
think the attorney told me the other day that the police chief said that he had not taken any action against the officers and, in fact, hadn't even conducted his own investigation of the incident.
That's not true, and there's been training and policy changes. Absolutely not true.
So what I want to get into is these broad exemptions under the California Public Records Act that say that anything that is deemed investigatory, that is part of a police investigation, can be deemed, out of the public view. The police can withhold. The police don't have to reveal the Force Investigation Division report on the Ezell Ford shooting at the LAPD, or any given, shooting, or even broader reports. What we're finding are broader reports that look at I think it was in the Long Beach case, that looked at the pattern or the more statistical information that might suggest problems with whatever's happening. So Neil, you're keeping silent. I don't know if that's on purpose or because I haven't
I don't
to
like
you.
interrupting people.
Yeah. Oh, right.
They were on a roll and they didn't need my
Well,
help.
sure. But you're a guy who's now in the position of setting police policy at the sheriff's department. And
Okay.
so, justify as a police law enforcement executive why these reports, broader reports on what happens within an agency, or specific Force Investigation Division reports are kept secret.
You asked two questions, so I'll answer them in order. There are so many threads I could pick up, and I'd love to, but how many people want to be here at midnight? So here we go. I'll try to be focused here.
We're going to get questions too in a second.
In my department, for instance, we've been on a road since I began in 1974, and especially since I've been a lieutenant or higher since the mid-1980s, toward more and more openness about these kinds of records. And I can't justify anything about an agency in the modern era refraining from publicizing overall generalized reports about such things as statistical information about use of force incidents, statistical information about officer or deputy involved shootings, and that sort of thing. You asked a second question about individual circumstances. I'll address that in a minute. But we are, in our department, for instance, right now in the process of developing a website page that would give the public very detailed information without the deputies' names about force incidents, shooting incidents, and even about discipline. But it's general information that doesn't violate any state law currently, either 6254F of the government code nor 832.7 of the penal code about peace officer personnel records. In other words, no names of deputies. With respect to the specific incidents, such as Gardena, about which I won't comment, we've heard a lot about it. I know nothing about it in detail, and I understand the case has been decided, and both these ladies worked very hard on it, so I have no standing to say what should have happened. I understand both sides of that incident, but with respect to specific incidents that are under investigation, no, I don't think that 6254F's exception to that being disclosed with respect to in-progress law enforcement investigations is too broad. I know that, just from experience, that the state legislators who wrote that section, who have amended it since then, worked very hard to achieve what I think everybody in this audience would want, and that's balance about the law. This whole program is about balancing what Peter talked about at the beginning, democracy and individual rights, and in particular retaining it by having the public's right to know what government's doing, against public safety and against privacy interest, which we value both of them in America. So my concern's always with how do we balance, and typically the balance is the way that Missy and Rochelle found out, and that's a court decision. So the PRA Act has exceptions, and of course people can contest whether we're applying the exceptions fairly and in a public safety and public's right to know manner. Typically, that's going to take a judge to decide. Now, that's as responsive as I can be there, and I'll skip the rest of it unless you want me to continue.
I would like an answer just on why officers' names should be kept secret. They are playing a special role in society. They're carrying a badge, they're carrying a gun, they have the right to detain people and play a specific function. And so maybe Jeff, you should answer that about why we shouldn't know an officer's name that was involved in an incident.
Well, why don't we publish all of our names in some place with our addresses and all of our information?
Well, I didn't say addresses. I just said.
Well,
yeah.
but you'll be able to track me down. What do you need?
Who'll track you down?
I mean, anyone can track us down, right? We know there are people who want to do us harm. We've lost 2 deputies in the last couple of years who were killed at their home, right? You do know that. And so we are concerned about our safety when we're off duty. When we're on duty, we're aware of the risk. We don't want to take the risk home to our families.
But that risk, and it is tragic anytime a police officer dies in the line of duty, but that risk is just part of being a police officer. Is there any...
Please, you did not say
It's-
that. We
it-
understand
it's-
the risk when we're at the job. We should and not put ourselves nor our family at risk off
But
duty.
that's not my point. My point is you interact with people on a daily basis, and does transparency or does disclosure of information under the CPRA actually increase a risk? You are at risk by virtue of the job, and that is unfortunate. But I'm not aware of anything to suggest that transparency under the CPRA increases a risk, and the California Supreme Court has rejected the idea that kind of speculative risk would be enough to deprive the public of information that's otherwise available.
May I address that?
Specifically regarding.
Yeah, go ahead, Neil.
names of officers.
Go ahead, Neil.
Well, I just want to say that, first of all, I understand Jeff's concern about the personal safety and the family safety aspect about this, because there are instances in which that's an issue. And of course, I know, we don't, in the Sheriff's Department, we follow the law. And if the law is that we shall release names absent a credible, explainable reason why there's a real, genuine, specific public safety threat to an officer or deputy, we won't release those names, and we can argue in court about whether it's legit or not. But I want to make it clear to the group that there are ways to be transparent that don't involve revealing individual officers' names. That's what the Sheriff's Department, by coincidence, or maybe by design, that's why I'm here, is working so hard on now with our latest in a series of, since 1993, several iterations of oversight. Non-sworn, non-peace officer, what people refer to differently as civilian or citizen oversight of the Sheriff's Department. We've had experiences with that since 1993, when a special counsel to the board began having deep level access to the confidential records we're talking about. And that person, whose name was Merrick Bobb and is still in business today as a police auditor, looked at every aspect of our department as though he had an x-ray machine. He didn't report everything to the board of supervisors that hired him about the detailed levels concerning officers' names and such, but he did report to them about details about incidents, and he reported to them about the broad general
Neil,
statistical stuff.
if I could just interject here, I mean, it sounds like you're arguing that the Sheriff's Department loves transparency and is very open and is happy to share information. I want to point out, just parenthetically, that you're opposing handing over personnel information, not even to the public, but to the Inspector General, Max Huntsman. At least to date, you've opposed handing that over to Huntsman and to the Civilian Oversight Board that's to be created.
Glad to respond. Merrick Bobb and his successor, the Office of Independent Review, were in a different category of oversight entities from the current Inspector General. We've been working with the Inspector General and, in effect, with the board, and unbeknownst to the group, for a year and a half, I've been the guy working on it, to deepen Max Huntsman, the IG's access to the department, and we're poised to do that.
Okay.
But there are many other considerations about which you don't want to hear right now, I'm sure, because it'll take us
Well,
off the track.
but this gets to access not just to the public, but to folks who are not even the public, but somebody who is an inspector general. But beyond that, I want to ask you to respond, because this is not just about officers' names or reports on shootings or even sort of internal reports on patterns of shootings, like with the Long Beach case. But in the I believe in the license plate recognition case, the Los Angeles Sheriff's Department fought vigorously to keep from public view all of the data that the department and the LAPD, for that matter, is collecting in terms of license plate data. So I want you to comment on that, but I want to hear Neil's sort of argument on why the department doesn't want to release that broader, because obviously police departments are collecting more and more and more information.
You know, I do not know about the license plate reader case. If anyone on the panel knows more than I do, they could inform you better. I admit I'm ignorant. I can tell you that, as far as I can tell, one guess would be this is a matter just like the body-worn cameras. We can film every plate, run it, and know whether it's a car that's stolen or wanted for a felony or whatever. And if people want every plate we notice or record with our equipment made public, there are significant privacy issues with that. I don't know that that's our premise. I apologize for not knowing about that case.
The argument is based on the investigatory exemption, and the second district, about 4 weeks ago, held, or no, it was longer than that, I apologize. There's a Supreme Court petition for review pending. The second district court of appeal here in the Los Angeles area held that all of the data is exempt from disclosure under 6254F. It's a huge amount of data. It's, I think in the petition for review, they say 0.02% of the data being gathered is actually relevant to any kind of pending investigation or anything. Meaning that 0.02% of the cars whose license plate is grabbed relates to a stolen vehicle or some other potentially pending investigation. The LASD is grabbing 1.2 million license plates a week. The LAPD is 1.7 to 1.8 million license plates a week. They're keeping that data for years so that they can go back and use it in other ways. And the ACLU's point was that the investigative exemption has never been applied in this way to just that broad gathering of information, which I think is quite Orwellian. It's amazing the amount of data that the Sheriff's Department and the LAPD are gathering about.
That, at least according to the latest ruling, will remain out of public view.
Unless the Supreme Court grants a petition for review that's pending, or the legislature steps in.
Do you have an opinion on that? I know you're not involved in that case, but
Actually, I have a very strong opinion. If you look up, you can use the internet to do this, by the way, look up the automated license plate reader program and how it was developed. It was developed in the UK to prevent bombings in central London. The man who brought that program to the West Coast and introduced it to agencies here stayed in my house for 6 months when he brought, after his responsibility for supervising that program as a test program in the UK. I'm very familiar with it. Ladies and gentlemen, that is a law enforcement tool with great power. The UK held on to that program for 10 years, and once they developed that program, they had no bombings in central London as a result of car bombs being brought in by the IRA. It's a very powerful criminal investigative tool, and I don't think any of us want our license plates to, once that information becomes public, it's accessible, your movements could be tracked anywhere by people who wanted to invest the time and the effort. Anybody could be traced, whether it was your peace officers being tracked to their homes, your Department of Defense personnel, et cetera. There would be no limit. While that information is secure in a law enforcement agency's coffers, it is hopefully, unless it's hacked for God's sake, it is not susceptible to abuse.
Well, how
It
do
is
we-
only used for criminal investigations.
How do we know it wouldn't be abused by the police department?
so it sounds like people might have
Actually-
questions. So let's raise your hand. We have a couple of folks here Jack, I think it's just Jack, as you guys raise your hands, get your questions ready. Give us your most frustrating effort to get records from a police agency that you thought you darn well deserved, and couldn't get your hands on them.
Well, I think it would probably come down to the disciplinary records that that Neil Tyler was talking about earlier. You know, we give police officers a lot of power. We invest in them the ability to and the duty to investigate serious crimes, and also we give them the legal right to use deadly force and other types of force. And yet, when individual officers are found by a police department to have in some way abused that right or committed misconduct, we don't get to find out. We don't get to find out who the officers are who have used excessive force, who the department has decided have used excessive force, and how they were disciplined. So there's no accountability.
We won't know if they're fired, and I suppose, Neil, your response is you'll have to trust us.
No, as a matter of fact, it would be more complex than that, and this time I'd like to finish, if it's okay.
You got it. But you only have 60 seconds.
All right.
Minute and a half.
Once again, if the public wishes to know about the outcome of discipline in, for instance, shootings or force cases, we're going to be publishing a good deal of that data in the near future. If the Times wanted it right now, there'd be certain things we could give the Times. There'd be other things we wouldn't. And it's based on current state law, both about 6254 of the Government Code and 832.7 of the Penal Code. It'd be illegal for us to do what Jack's asking for right now. The law is the law, and we're following it.
And it's illegal because police unions and, in fact, police executives for a long time have fought in Sacramento for these very policies, right?
There's actually, there's actually, I think, a distinction to be made in this particular area between police, the police captains, the commanders in many police departments, and the rank and file, so to speak. This reflects the particular provisions we're talking about here, which are highly protective of police due process and police privacy, go way beyond what many police department captains feel comfortable with. In other words, they find themselves in a situation where, as the head of a police department, some of them, they wish to be more open, more transparent with the public. And they would be if they could, but they find their hands are tied by these provisions in the Penal Code, which came about through the extraordinarily powerful lobbying of police interests. But when I say police interests, I mean police personnel, police officers, not the senior commanders.
Can I circle back
right?
to the
Because as
PPO?
managers, a police captain, a good one, a responsible one, very often recognizes the need to be more open and communicative with the community than would than the union leadership, for example, for the police officers would like.
I do hear that all the time. I wish we could give you this, but I don't see a stampede to Sacramento to change anything.
Okay. So let's get this question in, and Jeff, I also want to get back to you, because I don't want to, we have to be careful here that we don't beat up on cops. I mean, they have some real, and there's some real fears here, but I'll get back to you in a second. Let's just say who you are just for the heck of it and what
Thank
you do.
you, Frank. My name is Jorge Gonzalez, and I'm a civil rights attorney. I'm usually sitting across the table from Ms. Olin. So I want to bring up a case in point to give people an example, a flavor of what it is that we're talking about in the very real world. I often say, welcome to my world. I have an African-American woman from South Central LA. February of 2013, her son was killed by an undercover LAPD officer. And I filed a CPRA request asking for the file, the investigative file in that case, and the LAPD not only did not respond in 10 days, they've never responded. And they won't. And they know that the reason why they don't have to is because essentially the case law favors that exemption, that if the case is under investigation still, they don't have to turn over the documents. My response to that is a suspicious mind might be thinking they're going to just sit on this forever and continue to say that it's under investigation. And the 2-year statute of limitations will lapse, and we will never find out the information necessary to determine whether or not a good case exists that we should file. And I also filed a CPRA request to the DA's office, and they said the same thing. So a year and a half has passed. The statute of limitations is 2 years. What are we supposed to do?
So it's good to note that it's not just journalists that use the California Public Records Act to obtain information. It's attorneys and just citizen watchdogs, of which there are more and more citizen watchdogs and blogs that use the CPRA. Does somebody want to answer that question or tackle it? Yeah, sure.
Jorge and I just finished a trial in Fresno together. My verdict was in 35 minutes. It actually was 10, Jorge, by the way. I love you.
You beat Jorge in
Yeah,
court.
I did.
Yeah, we
Sorry.
got it. Just to make
Actually, I
sure.
find your question disingenuous because if you filed that lawsuit right now in federal court, you know and I know that you would file discovery, serve discovery on LAPD, and a federal judge would take up your issue with regard to whether or not those records were going to be produced in that case.
Should I file without knowing the facts? Would you advocate that I file without knowing what happened?
I would say that I won't point the finger at you, but that plaintiffs' counsel frequently file without knowing the facts, quite
Because they
frankly.
have to.
Okay. Who's next? And then there's a gentleman over here who's very animated.
Peter Biebring. So I had Ms. Olin and Mr. Steck paint a fairly bleak picture about what would happen with more open access to peace officer records. But there are lots of states that have more open access. In fact, California has possibly one of the most restrictive laws with respect to access to officer records. So you have states like Texas and Florida that have open access once there's a finding of misconduct by a department, and probably about 10 states like that, and another 10 states, including Washington and Ohio and Connecticut, and red states like Alabama and Georgia that have just open access to officer records, even allegations of misconduct. What about the experience in those states do you not want to replicate? Is there a lesson there in those states? Is there anything going wrong? Has anything that you have said may come to pass happening in those states that says California shouldn't go that way?
Do you want to tackle that, Jeff?
Am I here to hear you right? You would like to change California law to more closely replicate Texas law? That's a serious question because there are certainly. Well, I thought that California led in civil rights protection. I want to protect all civil rights. Law enforcement officers are citizens just like you, and I want to protect all rights.
But they're public employees who have a very unique kind of protection. They perform one of the most important roles in society today, and yet the transparency that the government has agreed is good, that the legislature has agreed should apply across the board, doesn't apply to them. And so while we can get information about misconduct by teachers who also perform a very vital role, we can't get any information about the people who have the ability to do harm.
So you want to begin to take the civil rights away from law enforcement?
It's not a civil rights.
And then, as I understand, teachers next?
No.
Who's next?
That wasn't my point at all.
I just don't understand. I just don't understand whose rights you want to take away.
I think part of the challenge is if there's been misconduct and the chief or supervisors have determined there's misconduct and discipline is handed down, firing, suspension, I think the public, the position is the public wants to know what's happening to law enforcement officers who are engaged in bad behavior. Right. For instance, in the well known as L. Ford case, the Civilian Police Commission said it was at least for one officer, there was bad conduct. But we won't know what happens to that officer. So I think the question is sort of confidence in law enforcement.
And what about
So I think, can you answer, I mean, so in other words, I think we, public, I can't take a position because I'm the moderator. But the idea is, the sheriff's department is taking care of bad cops and firing them. We don't know that.
Well, I think Neil said that they're going to release what the discipline, but they're just not going to release the names. I don't know how the name is useful to you. I just don't.
But they're one agency, and they're just getting to that point after years of having issues. And we have many, many agencies across the state who are not required to be transparent, and where the public has no access to information that I think the public needs in order to hold them accountable. The CPRA is premised on the idea that we're entitled to check and to make sure the government is doing its job right. And that falls apart with police officers who perform one of the most important roles in society.
And quite frankly, we're missing the point. The legislature put these protections in place, I would suspect, on good cause, and they put in place a process for you to gain access to that information if you have a need. It requires a motion in court, and there must be good cause. You must show a need for it, okay? So that we don't retry officers over and over again with regard to their actions. If you had the number of complaints that are filed against officers for doing their job.
I don't think we were talking about the complaints. I understand there are a lot
But
of
that's
complaints.
what results in personnel actions.
Well, and then a supervisor determines if there was
Correct.
misconduct, and
Right.
we never know whether or not the determination or whether or not the officer was disciplined. I think that's what I was trying to get at. I think we have a question over here. Did you want to make a
I
quick?
just want to make a quick comment.
Quick.
Imagine, this happens a lot, okay? Imagine that you have an unfortunate encounter with a police officer, and you feel that your rights have been violated, or perhaps more probable for this audience, imagine that your son or daughter has, and so you file a complaint with the local police department where this officer is employed, and you sit back. You're a good citizen. You pay your taxes. You vote regularly, and you're prepared to sit back and let the process, as it currently exists, run its course. And you're prepared to even indulge the presumption at the beginning that justice will be done. And so, 3 months after you file this complaint, you pick up the phone or you go over to the police department and you ask for the status of the complaint. You'll be told, I'm sorry, that's a secret, you can't get it, it's totally exempt under the Public Records Act. 6 more months go by, you go and you ask the same question, you'll be told the same thing. Now, don't you think that at some point that father or that parent or the person directly involved ought to know what the outcome of this internal investigation was?
Go ahead.
Yes, and at the risk of having
Not having to file a lawsuit to find out.
Right.
Right.
At the risk of having words put in my mouth, I will say that in my department, we've handled public complaints both more poorly and better over my career. Right now, what happens if someone does call us or write us about a complaint, the policy is, and the procedure involves, they're getting an answer. I cannot sit up here and say that every one of 350 lieutenants who are accountable for these complaint inquiries are always extremely carefully, systematically explanatory every time. So I'll say up front, no, I'm not trying to convince anybody of anything. I'm just explaining that the policy and process in the Sheriff's Department does entail feedback to the complainant that's more than just can't tell you anything because of the Public Records Act exemptions and the whatever. I always tried, and I did a number of these when I was lieutenant, to explain to the complainant what the deputy told me, if it's about a deputy, normally it is, and explain that in many cases, I wasn't there, I wasn't a witness, and with body cameras, maybe this will be different, but there's a push. And I've talked to the deputy, and I've tried to explain your point of view. I'm explaining his to you. If you want to come in, we can do a conflict resolution session. We don't do many of those. Mostly deputies are sometimes willing, and in those cases, the citizens are not. but it's one of our, since 1993 even, attempts to be more open about how we do complaints. Can you guys cite me instances, more than one, when we didn't do so well? I'll bet you can. I can too. That's part of my job, to find them and to deal with them. But we would not tell somebody, as a matter of policy, we can't tell you anything about it, but we think the officer did fine. We try and be more explanatory in verbal, and we try and give them a letter that's a little more than a form letter. 3 questions. Go ahead.
I have to say, this is where Neil, I know it seems like Neil and I are best friends, but this is where we sometimes disagree. Our policy is, if you make a complaint, the complaint will be taken and investigated. We have officers who have been investigated for smiling.
Wait, we're talking about public records and access to public records. So I appreciate the response to complaints, but I think what we're talking about is, for instance, for a long time, LAPD we couldn't get access to broad data on how many complaints were filed, how many were upheld, what was the result for each of these complaints. I know part of what I hear is this attitude of trust us. We will, I think it was Ronald Reagan that said trust but verify, right?
First of all, the computer systems are enabling departments to be better responsive to your statistical questions, I'm sure. But the fact is that when they get asked these, what's the stage of the investigation? Is it complete or not complete? My belief is you should and will get an answer. Was there a finding? They're not going to give you typically an elaborate answer, but the finding, whether it's sustained, unsustained, unfounded, exonerated, and that's put in writing, in my experience.
But the parent can never know if the officer was disciplined for beating up their child. And that's a problem. And the problem is that you can't track officers who have problems. There was a San Francisco Chronicle reporting about a decade ago that used use of force logs, handwritten logs, because the personnel records aren't available, to evaluate how many officers use force in San Francisco. And they determined that 100 officers of the 2,200 officers on that department were primarily responsible for the use of force. And if those records hadn't been uniquely available, they wouldn't have been able to find that. And it's the officers who use force more, who have a problem that the police department perhaps isn't addressing. The public is entitled to evaluate that information. And the PICHA statutes prohibit that, and our position is that they need to be changed because that's information that the public needs to have in some form, not unsubstantiated. Thank you. Not unsubstantiated allegations, but allegations that have substance to them. There's no reason why the public shouldn't be able to get that to make sure the police department is doing its job.
Let's get to a couple more questions in here.
Hi, my name is Hank Fong. And my question is that right now, for example, as a county employee, you have Civil Service Commission. If a doctor kills somebody, those records are in Civil Service Commission, they're public records. If you have engineer, I'm an engineer and people file complaints against me to the state board, that's a public record. How, if some of the police representatives could indicate how they feel that police should be different from other public employees like teachers and doctors that may cause injury or death to other people.
Go ahead.
Well, one of the first things that occurs to me is that my officers make split-second decisions in life-threatening circumstances. You as an engineer, a doctor, et cetera, most professionals have an opportunity to step back and evaluate and make very long-term committees called decisions that are made. Officers have to respond to situations like you saw in Gardena, where a young man didn't do what the officers told him to do, didn't keep his hands up, reached for his right side repeatedly because he was concerned about dropping his meth on the ground and clearing his pockets, as my officers repeatedly told him to keep his hands up or he would be shot. They made a split-second decision in life-threatening circumstances.
But isn't that a reason?
I thought that was responsive. Apologies.
So what is your point, Ms.?
Why should you not be able to see those records over and over again? I thought that was your question, right?
The question is, You sort of switched over here to legitimate and non-legitimate shootings under Graham versus Connor, right?
No, I took the young man's question, Mr. Fong. I'm sorry, I can't really see you all that well in the dark, sorry. Mr. Fong, I took the young man's question to be, why should the records of engineers and doctors, when they are allegedly making mistakes, be readily available?
Which they are,
and
right.
why aren't police officers' mistakes or alleged mistakes readily available? Did I get that right? Yeah. Okay, my
And
response
you said because
is,
they're making split-second decisions.
yeah, they're under the totality of the circumstances that we evaluate them. Those are very
We got
complicated
into
and
this discussion
complex
a little.
evaluations.
We got into this discussion a little earlier, and it's interesting because you're suggesting that the public is not sophisticated enough to understand that. Which I think, were we talking about that, Jeff, a little bit earlier today on the phone, and sort of the ability for people to look at that video and maybe a summary of the circumstances that led to what happened, the robbery call, the initial sergeant, the other 3 officers who arrived, the hands that you can't see for a second, and that people can't, in this world where there's so much video out there, make a decision, their own sophisticated evaluation in the way that they would an engineer or a doctor. They look on a website and he's, removed the kidney when he was supposed to remove the liver, and they could make a decision. So you're suggesting that the public is unable to sort of make that kind of evaluation?
Well, we trust juries when we impanel them, but they sit for days and listen to hours and hours of testimony. And quite frankly, synopsizing it in a simple fashion is probably more complex than is fair to the officers. I would say that would be one of my positions, yes. We have the Graham factors, the officer subject factors, everything that goes into deciding whether an officer's actions were objectively reasonable under the totality of the circumstances. And
so the fear is the officers will not be fairly judged by the broad public.
that's one of the fears, yes. That is part of the concern.
We have a unique job, and I love the job. But we have the one job where everyone knows how to do my job. And you tell me how to do my job frequently. I have never looked at an engineer's report of his malfeasance of causing a bridge to collapse. I've never done that. I've never wanted to see it. Maybe I should ask for it. I guess it's so readily available. It is complicated, right? I watched this video, and I am close to an expert on analyzing a video, and I can't draw a conclusion from that. And so to expect a citizen without my training to be able to draw a valid conclusion, it is complicated.
We're in a world now where information is readily available all the time, and people, are armed with a lot of information, and maybe this is,
The primetime police academy audience thinks they know how to do an officer's job. I'm sorry, but that's true. And it's unfortunate.
Well, we
and
all
they're
think
not
we-
trained ninjas, and they're not Wyatt Earp with gunfighting skills that are unbelievable.
and
It
therefore,
is a difficult job.
and therefore, only the law enforcement executives should be privy to the information and the judgment, and then the decision and the discipline. In other words, back
When
to
a
the
jury
trust us.
sits, when a jury sits and listens to all of the information through an extensive process, we trust that they will listen and give us a verdict.
You would think
let's-
from this conversation, though, that the only discipline that isn't public involves split-second decisions, but it isn't. Sexual misconduct, a discipline for lying. We have no idea how departments actually deal with that because it's all secret. And we're not blaming the departments for not disclosing that because it's a problem with the law. But that's what we're here to discuss. There's a serious problem with California law and how the public is able to vet and hold accountable its police departments. If your boss, Jeff, you talked about politicians. Your boss, he might not like the term, but he is a politician. He's an elected representative of the county. And how are we supposed to, how are voters meant to judge whether he's doing a good job with discipline when they're not able to see that?
Well, part of the reason that engineers and doctors' mistakes are readily available is because in their profession, if I go to hire a doctor, I have the right to check on their credentials and their mistakes. The fact is that you don't get to pick police officers when they respond.
Well, some would argue that makes it even more important.
No,
Absolutely.
No.
You'd flip that on the other side. But let me point out, by the way, since Jack pointed out it's state law, so to some extent you're merely, following the very restrictive California Public Records Act. And it is a Democratic-controlled state. So you don't see Democrats, rushing to change this law and to
fight the unions on it.
to force more transparency. We have a question right here.
My name is Jenny John.
I know there are no Democrats in the room.
And my question is directed to Mr. Steck. Earlier, when you were explaining why officers' names should be kept secret, you referenced the killings of 2 deputies who were killed in their home. Could you clarify, to your knowledge, whether their deaths were related to a disclosure linked to CPRA or any sort of authorized public record?
No, ma'am, it was not. It was because they were known in the community as to be law enforcement officers.
Although isn't we had this discussion earlier too, the Glassell Park jail deputy may have been mistaken for a gang member. So we don't know if they were killed because, at least he was killed because he was a deputy. You want to just say your name and what community you're from?
My name is John Tarnoff. I live in Eagle Rock, and I'm not involved in law enforcement, journalism, just a citizen. I have to say I'm very disappointed in this conversation tonight. I feel like the subject matter and the reason we're here tonight is to learn something new and to learn something constructive. And I feel like there's been a tremendous amount of defensive of the panel about these issues. We're in the weeds with the details, back and forth. I'd like to ask you guys, and I appreciate Neil coming in to talk about what proactive efforts that the Sheriff's Department is doing to actually address some of these issues. Guys, there's a problem. We wouldn't be sitting here if there weren't a problem. So it's no use trying to defend the behavior of the police departments. It's no use trying to hammer the police about, what should or should not happen. We have to figure this out as a community, as a state, as a country. So I'd like you guys.
By the way, when you say there's a problem with policing or a problem with access to records?
Well, there's a problem with. I think there's a problem certainly with access to records, the subject matter of your panel, and the issue I think grows out of the fact that we are perceiving a disconnect between our perception of the responsibility of the police to discharge their duties in an equitable manner. So the lack of information is obviously playing a very big part about this. And I think Peter's point about putting the video, making the video available proactively as a way of diffusing potential issues. You were talking about cities burning. Well, I think the reason cities burned was because the communities, the departments and the governments in these instances did not make this information available, engaged in very, very poor public relations and communications with their communities, which fueled frustration. So there's some very...
What question would you like answered right now?
I would like you guys to be more constructive together as a panel to try to talk about solutions and to talk about where we can move forward as opposed to trying to defend the past or get into the weeds of the specifics.
Well, let me respond. People ask me why and what the basis of our position is. I'm answering. It's not my personal opinion you ask me for, or how do we fix this. You ask me, why do we do this way, or what is the reason?
No, he is asking how would you fix
So I think my perception is that the folks who are with law enforcement and representing law enforcement are comfortable with the current laws.
Yes, sir, but let's go to answer your question. I agree completely. But you put 4 attorneys up here. Of course you're going to be in the weeds and not talk about the main thing, right? Of course. Right? And this is not about transparency of your records. This is about loss of trust in your police. That's what it's about. Because if you trust your police, you're not worried about seeing the records, right? So that's what we have to address. That's the core problem.
So my sense...
Now, if we do this, if you trust me, that's what makes you trust me?
So So
Absolutely.
let me try to address this before we get way out of hand here. Which
Remember this, trust but verify was the Soviet Union versus America. Is that how you view your law enforcement? That you've already lost.
So let me get to kind of balance the public records discussion, which I think that was the purpose of this panel. But I think you're trying to get to something a little broader, which is just policing and trust in policing. And so if the three sort of law enforcement representatives are comfortable with the current laws as they are, as sufficient to foster public trust.
No,
You don't.
that's right.
Okay. What would you change in the law to foster public trust?
Now, I don't want to sound like a commercial here, but here goes. The whole purpose to the Board of Supervisors making a motion and approving it to establish a Civilian Oversight Commission has to do with giving us another set of eyes and ears. It may look like a big adversarial thing setting up, but that is not the way the sheriff of Los Angeles County is viewing it. He's viewing it that this will be an opportunity for the sheriff's department to help build public trust. He's viewing it that our cooperation with them, which has to be worked out in certain levels of detail, and our cooperation with the existing Inspector General is a key to enhancing public trust. And every bit of that cooperation has to do with access to police records. He's moving carefully and wisely about the details. The devil's always in them, and we're agonizingly and painstakingly working on them. That's what I've spent most of my year and a half back to work doing. I can't brag about anything I'm achieving, but we're moving toward more, and I hate this word by now, but transparency, more access, real access. And right now, if Max Huntsman were here, he'd argue, Neil, you haven't given it to me yet. And I'd be saying, Max, we've been working on it. Don't mislead these people. There's a good faith effort toward doing what this gentleman's talking about. And that's why I said no, because this is going to take county code sections and even some memorandum of agreement or two among us, the Civilian Oversight Commission, the Sheriff's Department, the Oversight Commission, and the IG. And that is all law, basically. It'll not modify 6254, but it'll put a different spin on our openness to sharing these kinds of confidential records with the appropriate level to properly balance public safety against all the factors of democracy that Peter was concerned about which I am too. I don't want to live in a police state.
I think Rochelle has a constructive solution.
I think the constructive solution is talk to your representatives about amending the PITCHA statutes. The
PITCHA statutes. Describe the PITCHA statutes.
The PITCHA statutes were adopted years ago to address civil discovery in litigation. But in 2006, the Supreme Court interpreted them as also applying to the CPRA and as prohibiting disclosure of police personnel records in response to a CPRA request. And they have been, police agencies now try to push them as far as they could go. They use the PITCHA statutes to try to prevent us from getting police officer names when they're involved in critical shootings. The Supreme Court didn't let them do that, but they also use the PITCHA statutes to, for example, prevent police agencies from disclosing reports where the Pasadena is trying to get information to its citizens about a report it conducted on the shooting you mentioned earlier. The PITCHA statutes both constrain police departments in their ability to communicate with the public, and they constrain the public in their ability to force police departments to give them information. And they need to be changed. And unless the public stands up and starts making noise to their representatives and counters the police unions who really like the PITCHA statutes the way they are, not much is going to happen.
So let me flip that, and I assume you would not support that constructive solution, Missy. Instead, what would you do to increase transparency and access to foster trust in law enforcement?
I believe the Los Angeles County Sheriff's Department is on the right track with regard to the construction of databases that provide information without exposing individuals to specific attack and scrutiny with names. Okay. And the fact that they have this process in place that they've developed. Quite frankly, I don't know why anybody wants to do the job anymore. They question why they've taken on this role as your protectors. And the fact is that they are subject to ambush and attack. And you may not understand that or believe that, but that is the truth. And they go to work every day to come to your house when you're having a bad day.
I
and
think we
help
have
you.
we have an audience that understands that.
I
think
don't know
clearly,
that. I-
yeah, I think we do. Jack, did you want to weigh in? I saw you waving your hand. Was that too?
Well, I was just going to say that it's all very well creating another layer of oversight, but that oversight often doesn't actually lead to the transparency that we're talking about today. The Sheriff's Department had numerous watchdogs back in 2011. The Sheriff's Department at that time told us when the ACLU complained about inmate beatings that no, all these investigations, all these claims are investigated thoroughly. And now what we have is 5 sheriff's deputies recently convicted in federal court of beating a jail visitor. We have 7 sheriff's deputies convicted of obstructing a federal investigation. We have the former number 2 in the office.
And you're saying more public records availability would have prevented that? Or
Well,
somehow?
maybe we would be able to vet what the department is doing. The public will be able to, journalists would be able to. Clearly something was amiss and what we were being told wasn't true.
Let's get one more question in. Who wants to do it? Okay.
Hi, I'm Bob Pinsler from Redondo Beach. I was a former elected official, and also I was the business associate of the gentleman who lived in Missy's house for 6 months. So I know both sides of this issue. One of the things that has always struck me is how far behind the law is to technology. What would you change in the law to deal with the way technology is today and the way technology is growing so that we don't have these arguments? License plate readers are a perfect example. It's a far less benign issue than what it is that you're speaking about. Lots of data is being gathered. But if you are working a cold case and you would like some information from 3 years ago and a license plate would mean something, is that a worthwhile thing to have? In the situation where databases are being hacked on a regular basis and security in government agencies is not exactly the best. So where does this all fit, and where does the legislator work that you would like to see?
Oh, that's a big, broad question. Peter, do you want to?
I'll take a shot. You know, the legislative process is a wonderful thing, but it can take a long time. And since your question is really addressed to the speed with which technology creates new issues, the legislative process is probably not going to be the ultimate solution to these ever-changing and mutating issues. And I think that there are other ways to do it. I think that at the very highest levels in this state, for example, we could have a commission of mostly of police, but also others involved too, who in a public fashion would be focused on establishing best practices for police across the state. I don't know whether they would necessarily have to be binding, but if the best minds thought that they were the best practices, and lots of police departments refused to abide by them, I think the people to whom they are accountable would want to have some questions answered. But for example, when it comes to technology, the technology of reading license plates, or another example similar is the use of IMSI, or they're called stingrays, that when they're used by the police have the capability not only of capturing the metadata of your cell phone call because they're focusing on you, but also, by the way, the cell phone calls of everybody within a radius of X miles to you, or everybody in this room. And all that data has the potential of being gathered, stored, and misused. But if you ask police departments what their rules are and their standards are, they will tell you, we won't talk to you about it. We will tell you nothing about it. And so far as we know, they're abusing it every day, or they're abiding by the strictest standards, but we just don't know. Now, there ought to be a place where these kinds of questions are debated openly, and where people consider different proposals, where the interests not only of the police, but also privacy interests of legitimate privacy interests of police and victims and witnesses are considered, and the interest founded in the First Amendment of the public at large to information. Very often, these are competing considerations, particularly when it comes to technology. In the area of technology, access and the First Amendment sometimes are in conflict with rights of privacy of individuals. I'm not going to deny that. There ought to be a place, and the governor is probably going to have to take the lead on this rather than the legislature, where these kinds of issues can be hashed out and then best practices can be published and made available for all police departments to follow. And if they decide not to, I think they have some explaining to do.
Let me throw on, yeah.
I'd just like to be the first to say that was an excellent answer, and I agree with every part of it. I would have said something much less sophisticated. I'm glad he did it.
So let me just ask one last question to the two attorneys here, Rochelle, Missy. Is the overall trend, is it harder to get information out of police agencies, or is it getting easier?
I don't know that I would say either. I mean, I think that the investigative exemption and the PITCHA statutes have been largely the same for a while. We've been getting similar types of information. I think police unions are trying to push in the face of Copley Press, which was a 2006 decision that I referred to earlier. The police unions have been trying to push the PITCHA statutes farther, but the Supreme Court has held a good line.
And Missy, are you, as somebody who's protecting records or trying to, maintain some level of protection, are you getting more and more? Are you fighting more and more to more and more folks who are trying to get access to various police records?
You invited me here to deal with the anti-disclosure perspective, by the way, so I have. The fact is that we encourage our departments to not take what we call a bunker mentality, not to hunker down and to refuse to answer questions.
And do law enforcement executives tend to want to do that?
And they are listening. They are stepping out in front of cameras more and more often, answering questions. Now, they have to obey the law with regard to the pitches issues. They cannot, even if they want to, quite frankly, when my police chiefs terminate someone, they can't even turn to the rest of the department and explain why. Okay, that officer could run around and say, "I didn't do anything wrong. That was wrong for that chief to let me go." They can't even explain that. Not only can't they explain it to you, they can't explain it to the other members of their department. So the fact is that we do encourage departments to be more forthcoming, but they also have to act within the law. That's the bottom line. The law is what the law is. Do I agree that there should be some processes put in place that deal with good cause and things that need to be disclosed? Absolutely. But the law is currently the state of our discussion here tonight.
And safe to say the law in California it tends to favor police and protection of police records. And on that note, I think we are finished. Is that right? Okay. Thank you to our guests. Thank you to all of you for showing up. I appreciate the discussion.